Visible and audible?
Yes, of course, Mr. Subramanian.
Thank you, my lord. My lords, I wish to begin by saying that in constitutional arguments, there can be multiple approaches.
From London, my lord. London is behind all these problems.
May I only correct my friend, my lord, I don't live in London. I'm only in the suburbs. My lord, having said that, there are, my lord, multiple approaches. One, my lord, is what we call traditionally the historical argument. The second, my lord, would be a textual argument. The third is a doctrinal argument. The fourth is prudential, and the last is structural argument. Well, these are all well-known methods of interpreting a constitution. These are broadly, my lord, the topology of constitutional arguments. In this case, whatever approach, my lord, we may adopt, the end result will be the same. Whichever way we proceed to look at this matter, there will be...
Subramanian, who are you appearing for in this batch of cases?
I'm appearing, my lord, so if I may just point out to it, I'm appearing in writ petition civil 1104 of 2019.
And petitioner there?
Yes, my lord, there is a petitioner, Muzaffar Iqbal Khan. Yes. My lord, my written submissions are also on your lordship's record.
Yes, Mr. Subramanian.
So, my lords, I'm going to urge for your lordship's consideration 4 important propositions. The first is the Constitution of India and the Constitution of Jammu and Kashmir speak to each other. They exist together. And their complementary existence is the quintessence of the relationship between India and Jammu and Kashmir. The second.
So they speak to each other and
Yes.
complementary
And
existence.
they're complementary constitutions. With respect to Justice Nariman, in one of the judgments, he called it subordinate. I think the word is slightly inapposite. I would say complementary.
Yes.
The second, my lord, is that Constituent Assembly by its very definition is a primary assembly which is vested with this extraordinary task of framing a constitution. That is why, my lord, the amending power is always called a derived power. An amending power, a power to amend a constitution, is always called a derived power. And here, my lord, we have 2 constituent assemblies. The Constituent Assembly of India, and we also have, under the Constitution, recognized by the Constitution, a Constituent Assembly of Jammu and Kashmir. This is the second. But what is its implication, I'll deal with it. Then the third, the impugned orders, that is CO272 and CO273, in sum and substance do away with the Constitution of Jammu and Kashmir. That, my lord, is impermissible. It is not authorized. The last is about this expression people. Here, my lord, people have both the sense of being persons, but in the constitutional context, they have a legal and juridical existence.
Yes.
If I may now, my lord, submit. My Lord Honourable the Chief Justice yesterday made a very important observation, and it is perhaps a critical observation that in any representative democracy, we must look for expression through the institutions under the Constitution. And, my lord, I'm going to urge your lordships to consider that the expression constituent assembly and legislature of a state are both institutions recognized under our Constitution. I will submit, my lord, that the basic structure which your lordships have to discern in this case to determine whether there could be any abrogation of it will be deduced both from the Indian Constitution and the Jammu and Kashmir Constitution. I will also urge your lordships to employ.
Just
Yeah,
1 minute. 1 second. Yes, Mr. Brown.
I will urge your lordships to apply what is called the degree test or the effect test applied by Chief Justice Kapadia in a case called Glenrock. And it is by applying that test we assess the extent of abrogation. Most importantly, my lord, our Constitution recognizes asymmetric federalism. And the purpose of asymmetry is to take note of special conditions and special needs of people. Now, my lord, the great colossus, Dr. Ambedkar, introduced the Constitution, and his introductory speech had two themes. That speech, my lord, is available for your lordships in document volume 8. And in that opening speech, Dr. Ambedkar speaks about the Indian Constitution being federal. And he also says that people who live in a state can be given special rights, special privileges. There was another question which I think I heard my Lord Justice Gavai mention, which was there were also princes who merged their states at the time of the Constitution. There were agreements. What was the status of those agreements? Could they not be abrogated? And my lord, there is some answer which needs to be offered to that question. It's a very important question. Jammu and Kashmir was not like any other state at the time of accession. It was not like any other state. And I'll give your lordships 3 reasons. The first, Jammu and Kashmir was a state which had its own constitution prior to the act of accession. They had a constitution of 1939. Two, the accession by the Maharaja was qualified because people were still in the process of making up their mind. What, my lord, the Indian Constituent Assembly did is that just as they felt a decision can only be taken by the people of a country, they thought it's appropriate and necessary that the will of the people is ascertained. My lord, that is the first hallmark of this case. what did the Constituent Assembly and later in our constitutional text proffer to do? They maintained the highest sense of democracy and respect. Just as we are enacting and giving unto ourselves a constitution, we must give that Constituent Assembly to determine their future. And that, my lord, is the reason why in draft Article 306A, which was introduced by Mr. Gopalaswamy Iyengar, spoke about the Constituent Assembly of Jammu and Kashmir taking a decision. Now, my lords, the entire controversy or dispute has been presaged, if I may say so, on one misunderstanding. Namely, there is a unilateral exercise of power possible by the President under Article 370. This is how, my lord, we have looked at the provision. Now I'm going to show to your lordships, it is exactly the converse. What is the converse? I'll now take you, my lords, to some portions of the debates of the Constituent Assembly of Jammu and Kashmir, and then your lordships would notice what was their final resolution. My lords, they passed a resolution, and the text of that resolution is the answer to the case. It is an answer to many questions. We have been very uncertain that did the Constituent Assembly take a decision under Sub-Article 3? What was their position on Article 371? Your lordships will find answers. But I'm summing up first, my lord, so that your lordship knows what is that answer going to be. My lords, just as the Constituent Assembly debates of India are inspiring, the Constituent Assembly debates of Jammu and Kashmir are also inspiring. Your lordships will notice that it was really on the basis of Rousseau's model of representative democracy that the Constituent Assembly itself was formed. But more importantly, they took their decisions in 3 steps, my lord. 3 steps. The first is they left India in no manner of doubt that they have faith and respect for the people of India and are acceding to India. The second is, my lords, they were looking at all constitutions of the world, just like Sir B.N. Rao did, just like Dr. Ambedkar did. In fact, my lord, one of the greatest gifts of government publications are the complete collected works of Dr. Ambedkar, published by the Maharashtra government. And my lord, the editorial chairman is one Mr. R.M. Gavai. And that painstaking effort of putting all his letters together, and all his letters, my lord, are quite remarkable. Having said that, my lord, they had many constitutions to look at. They also looked at the Indian Constitution. And they said, we will need some special provisions for us. we will need some exceptions for us. One of the first states in India, my lord, which looked at land reform was Kashmir. It was actually their throbbing concern at that time that we must give rights over the land to people, and there must be permanent residence, and people must have rights. So, my lord, they wanted some exceptions. So the first time, my lord, decision to accede. Second, they said, we will frame our constitution, but we will request the government of India that its constitution, with the exceptions which we need for Jammu and Kashmir, must be brought into effect under Article 370. That is why, my lord, we have 3 constitutional orders, which I'll show you shortly, one of 50, 52, but most importantly, 54. My lord, it was the Constituent Assembly of Jammu and Kashmir which invited, under Article 371D, for the application of the provisions of the Constitution with exceptions which were required in Jammu and Kashmir. I'll show you, my lord, that resolution. You will see it very shortly. And, my lord, the government of India accepted that request and issued the 1954 order. And then they said, if we have already got an order subject to exceptions and modifications, and in that, my lord, they omitted many parts of our constitution because they wanted it to come in their own constitution, like legislature. So the legislature, my lord, is actually established under the J&K Constitution. The High Court of Jammu and Kashmir is established under the J&K Constitution. So they said, we will take the 54 order as Indian Constitution as applied to Jammu and Kashmir. And that is how, my lord, the Jammu and Kashmir Constitution was born in 1957. The Jammu and Kashmir Constitution on 26/1/1957 recognized the application of the provisions of the Indian Constitution under the 54 order, and also had separate provisions, including, my lord, the autonomy in respect of framing of laws. And this is quite important, my lord, because this is the way two constituent assemblies, as a product of their fruitful energies, through now the Constitution, speak to each other. So, my lords, even though the word temporary occurred in the marginal note, the resolution of the Constituent Assembly of Jammu and Kashmir, my lord, which I'm speaking and I'm putting it within quotes, was that the Constitution of India must apply with these modifications. But more importantly, they said, Article 1 and Article 370 must continue. I'm talking of an affirmative resolution, my lord, of a constituent assembly. It is not a matter of any non-formalistic expression. And it is that formal resolution read with the J&K Constitution, which finally, my lord, fall up for your interpretation. My lord, what is significant is the two constitutions, I said, speak to each other. Which is that provision through which they speak to each other? It is Article 370. So, my lord, Article 370 was not a repository of untrammeled power of application of constitutional provisions. No. Article 370 was the medium by which the Indian Constitution could be applied, and they could also act in terms of their constitution. And, my lord, here lies what I call as a dual obligation. The dual obligation, my lord, is to be discovered, one, in the words of section 147 of the Jammu and Kashmir Constitution. And the second are the words in Article 370 itself. In section 147, my lord, one of the laws which could never be touched by the Legislative Assembly ever in the exercise of its amending power was the provisions of the Constitution of India as applied to Jammu and Kashmir. This is, my lord, in some contrast. And again, I am deeply grateful to my lord, the Chief Justice, who, again, in a thought-provoking observation, referred to Article 372, the power of adaptations. And in that, your lordships will notice the president can bring it in accord with the Constitution, but the legislature of the state, which is competent, can always pass a law repealing, modifying, varying it. Your lordships recollect that provision in the Constitution. This is not there in 148 at all. So 148 treated the provisions of the Indian Constitution as sacrosanct. And, my lord, what did we under 370 offer? Under 370, we offered the ability to frame a constitution and the ability to offer our constitution subject to special exceptions. Your lordships have not seen those exceptions. When your lordship sees those exceptions, your lordships will appreciate that this is not a simple constitutional order. This is an order which is a product of bilateralism. And, my lords, our constitution, by its very nature, has so many checks and balances that bilateralism can be seen as at the imprimatur of our constitution. So, my lord, the only exceptional provisions where you can have unitary action are few, far, limited, and conditioned, my lord, by a temporary purpose. Having said that, my lord, may I just take you to a few documents so that I quickly make the point?
Yes.
I also want to say one thing, my lord. I had Mr. Sybil cite the decisions on Article 370 yesterday. There was one more, Justice Nariman's decision, which needs to be cited. But, my lord, I want to just sum up and tell you what are these decisions quintessentially saying. Justice Bhargava in Sampat Prakash notes that the Constituent Assembly did not want to abrogate Article 370 and instead permitted its continuance. When your lordship see that sentence with the resolution of the Constituent Assembly of Jammu and Kashmir, your lordships will be left with no manner of doubt that that is the correct legal position. The judgment in Damu, which was cited by Mr. Sybil, is a case, my lord, where there was an amendment to the Jammu and Kashmir Constitution by the Assembly, which was called the Sixth Amendment. In Jammu and Kashmir first. And Jammu and Kashmir said, Sadr-e-Riyasat will now mean governor. And therefore, my lord, Article 367 was amended to bring it in accord with Jammu and Kashmir Constitution. That is the judgment of Justice Sikri. But more importantly, my lord, Justice Sikri refers to this very judgment in Keshavananda Bharati and said that amendment did not alter the fundamentals or the basic structure of the Jammu and Kashmir Constitution. Now, my lords, just a quick recount of dates, and I go straight to what needs to be seen. Your lordships have been told that there was a 1939 constitution. And that, my lord, is Documents Volume 6, page 199. I'm not going to read it, but one of the features of that constitution, my lord, as Justice Gajendra Gadkar noted, is that the Maharaja had all legislative, judicial, all powers vested in the Maharaja under the 39 constitution. On 26/10/47 is where, my lord, Hari Singh signs the instrument of accession. Your lordships have seen it. It is Document Volume 1, page 9. But it was not, my lord, the kind of accession which many other Maharajas did, for the reason the other Maharajas signed supplementary instruments of accession and merger agreements. Now, between the time he signed the agreement and the drafting of our constitution, our Constituent Assembly, my lord, did not ask the Maharaja to discover the will of people. They acknowledged that there should be a Constituent Assembly by which the will of the people of Jammu and Kashmir is ascertained. So, my lords, even though he was the titular head, in some sense, the people of Jammu and Kashmir were acting now in a sovereign capacity to determine in a Constituent Assembly what should be their decision. This is the difference, my lord, between the cases where agreements have been superseded or privileges have been superseded And this case, why? Because when the accession happened completely, my lord, it was between the people of Jammu and Kashmir and India. Of course, my lord, your lordships have been told that on 27th October 1947, Lord Mountbatten, the Governor-General, accepted the instrument of accession, that is document volume 1, page 1112. And 5th of March 48, my lord, there was an interim government appointed by the Maharaja for administration. And 17th of October 1949 is the date when your lordships have referred to it. Documents volume 8, page 1173, when N. Gopalaswamy Iyengar introduced Article 306A. One day before, my lord, our constitution was going to be adopted. One day. On the 25th of November 49,
Sorry.
Maharaja,
Can you give us the date
25th,
again?
my lord, 25th.
25th of November.
November 49.
Yes.
The Maharaja of Jammu and Kashmir said, India is about to frame a new constitution, and for the sake of continuity, the provisions of that constitution must govern us till such time as is necessary. That is at, my lord, Documents Volume 4, page 379. My lords, on 26 January 1950, of course, our constitution came into force. But now I would like your lordships to go past this date and please see first the proclamation convening the J&K Constituent Assembly that is dated 1/5/51. And would your lordships kindly turn to Documents Volume 6, page 276. If your lordship sees this document, 276.
276.
This is the proclamation dated 1st of May 51, convening Jammu and Kashmir's Constituent Assembly. Whereas it is the general desire of the people of the state of Jammu and Kashmir that a Constituent Assembly should be brought into being for the purpose of framing a constitution for the state. Whereas it is commonly felt that the convening of the Assembly can no longer be delayed without detriment to the future well-being of the state, and whereas terms of the proclamation of the Maharaja dated 5th of March 1948 in regard to the convening of a National Assembly as contained in clauses 4 to 6 of the operative part, therefore do not meet the requirements of the present situation, which is why, my lord, the change of language. And please see, I, Yuvraj Karan Singh, do hereby direct a Constituent Assembly consisting of representatives of the people elected on the basis of adult franchise shall be constituted forthwith for the purpose of framing a constitution for the state of Jammu and Kashmir. Then, of course, my lord, there was the other logistics were set out in the rest of the proclamation. Now, my lord, after this, the Constituent Assembly of Jammu and Kashmir meets. And by this time, because of the instrument of accession, that certain entries in the union list on the three subjects, my lord, can be made applicable, the first constitutional order of 1950 was passed. And that, your lordships will find, is in document volume 3, and please see page 4 of that document volume.
Document volume 3, page 4.
And this is, my lord, the 1950 order. And your lordships will notice that this 1950 order takes place in consultation with the government of Jammu and Kashmir, because these are all in respect of matters connected with accession. Now, my lords, the second schedule also applied some provisions of the Constitution, because there must be a parliament, there has to be an acknowledgement to parliament, and your lordships will find there are 3 columns, my lord, in the schedule 2. One is provisions of the Constitution applicable, the second is exceptions, and the third is modifications. And your lordships will notice at page 7, in part 11, on the extreme right, clause 1 of article 246 shall apply, subject to the provisions of paragraph 2 of this order, and clauses 2 and 3 of 246 shall not apply in relation to the state. This order, my lord, as your lordships have seen, is the first order. Now, my lords, alongside, let me take you to the assembly. This is the beginning. And now let us see the Jammu and Kashmir Legislative Assembly itself. Your lordships will find this in Documents Volume 7.
What page of document 7?
Yes. Now, would your lordships kindly look at page 32? I'm, my lord, trying to set out the extraordinary goodwill between India and the state framing a constitution and how it was expressed. Please see page 32. It's Appendix A.
Where is this?
Page 32. PDF page 32, my lords. Message of goodwill.
Running page 1391.
Yes, that is the print page. And this, my lord, is the message from the President of the Indian Union. On this historic occasion of the inaugural meeting of their Constituent Assembly, I send my sincerest greetings to the people of Kashmir and their beloved leader, Sheikh Abdullah, and hope that the Assembly will be guided in its deliberations by the single aim of shaping the life of the people of Kashmir as to make them happy and prosperous. And then, my lord, your lordships may kindly come to page 250, PDF.
The same volume.
Of the same volume, my lord. Your lordship sees after, in quotation marks, Sheikh Muhammad Abdullah reads, and he says, and that, my lord, is only to indicate how they set about their debates. This assembly, which is the center of our hopes and aspirations, held its first meeting in the first week of November 1951. It is now meeting again after an interval of nearly 4 months. In the last session, I had drawn your attention to the fact that though this assembly possesses the unquestioned right to decide the future of the country, and that this House is going to exercise this right to the fullest measure, nevertheless, were anyone to question the right of the assembly to do so, we would be prepared to seek the verdict of the people outside on this question, and all that need be done in this connection is to create necessary conditions which would enable people to express their will freely. Then your lordships may kindly see 257. If your lordship see in the middle, this precisely is the important section 370 of the Indian Constitution. The sovereignty and unfettered powers of the Constituent Assembly have been recognized by the Indian Parliament. The present constitutional relationship between Kashmir and India has time and again been made clear by the Indian government and its prominent leaders. The speeches made by late Sardar Patel, Gopalaswamy Iyengar, and Nehru himself in this behalf are still fresh in the memory of people. Then, my lord, please come to page 796. My lord, just as our Constituent Assembly had established committees, my lord, as your lordships recollect, to frame articles for different purposes. Similarly, my lord, the Jammu and Kashmir Constituent Assembly did the same thing. So they had a basic principles committee. What are the basic principles on which that constitution will be framed? And your lordships will find this is the report at page 796, and your lordships will notice the first. The basic principles of the state constitution will contain provisions relating to the form of the state, the executive, the legislature, the judiciary, the public service commission, the official language, and other ancillary matters. The recommendations of the committee in regard to these matters are contained herein below. And please see, my lord, the first line. The state of Jammu and Kashmir will comprise such territories which form the part of the state on 15th August 47, while retaining its autonomous character. The state will continue to remain acceded with the Union of India. The sovereignty of the state resides in the people thereof, and shall except with regard to matters specifically entrusted to the Union be exercised on their behalf by the various organs of the state. The governing features of the state constitution would be based on democracy, equality, and social and economic justice. So, my lord, they give the broad outline of who will be the head, elected minister, who will be the members of the Legislative Assembly, and please see page 798. The second paragraph. the judiciary of the state will be independent of the executive. And then, my lord, they write about the High Court, and the High Court will also be a court of record. Then, my lord, appeals will lie to the Supreme Court. All this, my lord, is a part of the framework. And finally, we come, my lord, to page 800. The state of Jammu and Kashmir
800.
the second para, my lord. The state of Jammu and Kashmir having acceded to the Union of India, it becomes necessary to define the relationship of the state with centre. This relationship was originally based on the instrument of accession, whereby the state of Jammu and Kashmir acceded to the Union of India in matters of defense, foreign affairs, and communication. When the Dominion of India became a republic, the relationship of the state with the Union was embodied in Article 370 of the Constitution. The state's accession to the Union entails certain responsibilities on the centre for protecting the interests of the state and also for its social and economic development. In order to enable the centre to discharge its responsibilities, which devolve upon it under the Constitution, those provisions of the Constitution of India which may be necessary for this purpose should be made applicable to the state in an appropriate manner. While preserving the internal autonomy of the state, all the obligations which flow from the fact of accession and also its elaborations contain should find an appropriate place in the Constitution. And then, my lord, please notice the recommendation Roman 1, that a directive be issued to the drafting committee to bring up appropriate proposals defining the sphere of union jurisdiction in the state, suggesting additions, modifications, and amendments necessary to the Constitution application of Jammu and Kashmir order to suit the requirements of the state. So, my lord, my submission is that the Constitution of India was made applicable with exceptions and modifications as a part of the Constituent Assembly's decision. It was not, my lord, an imposition by the president at all. And your lordships will see just at the bottom, the drafting committee should forthwith take up the drafting of the constituent for the state in the light of the recommendations contained in the report and such other reports as have been or adopted by this assembly from time to time. Now, my lord, the drafting committee did make a report. And let me take you straight, my lord, to that. Your lordships will find this at PDF page 936. At the bottom, your lordships notice 11th of February 1954. This, my lord, is the report of the drafting committee. In pursuance of the directives contained in the reports of the Basic Principles Committee and the Advisory Committee on Fundamental Rights and Citizenship, as adopted by the House, the drafting committee has considered the question how best to give effect to the recommendations embodied in these reports. The task which the committee has to discharge requires action in the following directions. Number 1, preparation of the drafting constitution of the state, defining the sphere of union jurisdiction in the state and for that purpose, suggesting the various provisions of the Constitution of India, along with modifications and exceptions subject to which these provisions should apply to the state. These would include appropriate modifications and exceptions in Part 2, that is citizenship, and Part 3, fundamental rights, in their application to the state of Jammu and Kashmir, in the light of the recommendations contained in the report of the Advisory Committee on Citizenship and Fundamental Rights. But my lord, please see number 2, consequential amendments in the Jammu and Kashmir Constitution Act 1996. That is, my lord, the 1939 Constitution. Well, the 1996 is the 1939 Constitution. Now, my lord, let us go forward. Please see the last para on that page. The annexure to this report, while reflecting the desire of the House for the ratification of the accession of the state with the Union of India, indicates in detail provisions of the Constitution of India, which generally correspond to defense, foreign affairs, and communication, and such other matters as are considered essential concomitants of the fact of accession. In accordance with the directions contained in the reports referred to above, the committee has endeavored to clearly demarcate the sphere of union jurisdiction, keeping intact all along the residual powers of the state. And, my lord, this has an annexure at the bottom. As your lordship see, my lord, that annexure A to the drafting report. This, my lord, is drafted by the Constituent Assembly. This annexure A. The provisions of the Constitution, which in, sorry. Yes, I'm sorry, my lord. The provisions of the Constitution of India, which in addition to Article 1, and 370. My lord, this Article 1 and 370 is in the forefront of this annexure, should apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they should so apply will be as follows. So, my lord, preamble, then your lordships will see this proviso to Article 3. It says, cannot be introduced without the consent of the legislature of the state. My lords, all these are the exceptions and modifications wanted by the Constituent Assembly of Jammu and Kashmir to apply the Indian Constitution. And your lordships will also notice that this provided under Article 32 2A, PDF page 940. There's a modification, my lord, of Article 32. Please see page 940 PDF at the bottom, 2A. Without prejudice to the powers conferred by clauses 1 and 2, the High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases, any government within whose territories those territories, directions or orders or writs, including writs in the nature, habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them for the enforcement of any of the rights conferred by this part. And then, my lord, Article 35, your lordships will find, protects the laws which were made specially at the time of the commencement of the order. And that's why, my lord, you have Article 35A at PDF 941 about permanent residence and they being specially protected. But, my lord, this annexure goes on and on. Now, what your lordship see at 942, PDF 942, is part 11. In Articles 246, the words notwithstanding anything in clause 2 and 3, occurring in clause 1 and 2 and 3 and 4 shall be omitted. What they did, my lord, was they applied some parts, omitted some parts. That is, they omitted part 6 for states, they omitted part 7, they omitted part 8, they omitted part 9, they omitted part 10 of the Indian Constitution. And they applied this constitution. And this, my lord, your lordships will notice, is verbatim the 54 order, my lord. And if your lordships now kindly come to 949 PDF, I'll now show you the resolution. I'll show, my lord, the Constituent Assembly forwarding it to the Government of India. Please come, my lord, to 949 bottom. Sir, the report is before the House, Mr. Dogra. It is being discussed for the last 2 days. When it is adopted by the House, the long-standing desires of this country, for which we have been trying for the last 6 years, will be fulfilled. Its adoption by the House will make the accession of this country to India permanent. We are acceding to that India which is the defender of peace and which is trying to check the possibilities of war. If in any part of the world war breaks out or any disruption is created, India extends a hand of friendship and peace and saves that part of the world from the disaster of war. All this, my lord, is said. Then please come to, my lord, again, they speak feelingly about India and India offering the hand of friendship. My lord, that is stamped all over the debates. All over the debates. Your lordships will find very adulatory, praiseworthy references, my lord. But now let us come, my lord, to the resolution, which your lordships will find is at the resolution is at page, my lord, 978. This report, my lord, was accepted. This annexure. Please come, my lord, to the end of the page, 978, Girdari Lal Dogra. Sir, I beg to move the following resolution. Resolution that having adopted the report of the drafting committee, and B, having thus given its concurrence to the application of the provisions of the Constitution of India in the annexure to the said report, this assembly authorizes the government of the state to forward a copy of the said annexure to the government of India for appropriate action. And at the bottom, my lord, is the chair at page 979. He resolves. It's to the same effect, my lord. Now, my lord, this report is sent to the government of India from the Constituent Assembly. Now, my lords, the 54 order, which has now been superseded, is, kindly see, this is CO 48. This is, my lord, 1954. But before 1954, my lord, they also passed a resolution under Article 373, which your lordships will find is reflected at CO 44. Please see page, my lord, a PDF page 12. This is documents volume D3, page 12.
Volume? D3.
Volume 3, my lord,
U44.
CO 44. Well, not all these were COs, they were all constitutional orders. That is why they have that nomenclature. And please see this, my lord. The Constituent Assembly was conscious of what it was doing. And it said, in exercise of the powers conferred by Clause 3 of 370 of the Constitution of India, the President, on the recommendation of the Constituent Assembly of the State of Jammu and Kashmir, is pleased to declare that as from 17th November 52, the said Article 370 shall be operative, with the modification that for the explanation in Clause 1, the following explanation is substituted. So, my lord, you have one order under 373 which says the only change we want in 370 is the change of the explanation from the Maharaja to Sadr Riyasat. The second is they have asked for an application of the order, that is, my lord, the 54 order, also stating that Article 1 and 370 will continue to govern Jammu and Kashmir. Please see that. Now, my lord, this is the 54 order, which is at PDF page 13. And if your lordship see this order, in exercise of powers conferred by Clause 1 of
Where do we
Article...
find that, Mr. Subramaniam?
So sorry, my lord.
Next page?
This is page, my lord, 13 PDF.
Yes. Yes.
Now, please see, my lord, it says, Article 2, the provisions of the Constitution, which, in addition to Article 1 and Article 370, shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows. All these, my lord, correspond to Annexure A, resolved by the drafting, your lordship have seen, the Constituent Assembly, that Annexure A, which was forwarded to the Government of India. This is that Annexure A. This is, my lord, in response to my lord, the Chief Justice's question again yesterday. Was there any action of affirmation by the government? This is the action of affirmation. And now your lordships will see their constitution recognizes the Constitution of India as applied to Jammu and Kashmir. I'm going to show that, my lord, in a moment. So, my lord, the two articles speak to each other. The two constitutions speak to each other. But that could happen only through 370. And now let us look at, my lord, the Jammu and Kashmir Constitution. As I told your lordships, There were so many parts of the Indian Constitution which were accepted in the 54 order. So, my lord, in their constitution, they first recognized the Indian Constitution. They said we are an integral part of India. They said we have powers to legislate, except where Parliament of India has power to legislate. And they, my lord, created their legislature. Their statehood, my lord, is defined by their constitution. And now let us look at, my lord, the J&K Constitution. Your lordships will find that in volume documents 2, please. This is, my lord, it starts at PDF page 1. And if your lordships will straight away come to the preamble of the J&K Constitution, Justice Nariman has also extracted it in his judgment. But, my lord, this is a collective decision of the people. And we, the people of the state of Jammu and Kashmir, having solemnly resolved, in pursuance of the accession of the state to India, which took place on the 26th day of October 47, to further define the existing relationship of the state with the Union of India as an integral part thereof, and to secure ourselves. And, my lord, many parts have been inspired naturally from our constitution. But, my lord, the word secular, Justice Cole observed that the word secular was not here. That's in some other part of this constitution, my lord. There is another article which deals with secularism. Now, having said that, my lord, please come to over the leaf, that is at PDF 17. They chose, my lord, 26th of January 57 to correspond to India's date of 26 January 50. This constitution may be called the Constitution of Jammu and Kashmir. And would your lordship kindly come to section 2, 1A, most critical, my lord. This constitution recognized, my lord, the Constitution of India. And how did it define the constitution is important, my lord. It defined into 1A, Constitution of India means the Constitution of India as applicable in relation to the state. So, my lord, we have an act of affirmance from government accepting the suggestions that the constitution should be applied. They say, please apply it subject to exceptions and modifications. And government agrees. And, my lord, they make Constitution of India means this constitution. And, my lords, please see, section 147 should be interpreted in the light of this. That the legislature can never touch Constitution of India as applied to them. And, my lords, the question will be, where does anybody get the power to abrogate this constitution? This is the central question in the case. Now, my lord, in addition, now please read Article 3 of this constitution in this manner. And, my lord, it is necessary that relationship of the state with the Union of India. The state of Jammu and Kashmir is and shall be an integral part of the Union of India. It is an integral part, my lord, on the strength of the 54 order and applying the provisions of the Constitution. And then please see territory. Territory of the state shall comprise all the territories which on the 15th of day were under the sovereignty or suzerainty of the ruler of the state. You know, this is the distinction which I answered in the morning in response to Justice Gavai's question. Please see 5. The executive and legislative power of the state extends to all matters except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution of India. What, my lord, was attributed the expression residuary power, but, my lord, this is the rest of the power, excluding the powers of the Union Parliament. The rest is with the state legislature. Now, after this, my lord, you have to only see 2 more provisions. One is, my lord, I request your lordships to kindly look at section 92. But before that, my lord, I mentioned, please come to page PDF 25. The head of the state, my lord, is under this constitution. Page 25. The governor, my lord, is appointed under this constitution. The office of the governor finds a place for Jammu and Kashmir in this constitution. And your lordships will find section 35 is a council of ministers to aid and advise the governor. Even this form of government is enshrined in this constitution. And now if your lordships come to section 92, which is at PDF page, my lord, 59. Your lordships will find that this section 52 is 92, my lord, I'm sorry, is in stark distinction to the provisions in our constitution. So, my lord, the purpose of section 5 was that 370 must continue, the list allocation must continue, 246, 2 and 3 must not apply. But now let's look at 92. If at any time the governor is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of this constitution, the governor may assume to himself any or all functions of the government of the state, make incidental and consequential provisions, and so on. But your lordships notice he is not in a position to exercise the powers of the legislature. And he has to do this, my lord, get popular government within 6 months. Because if you see 92.3, it ceases to operate on the expiration of 6 months from the date on which it was first issued. So, my lord, popular representative government is a part of the architecture of section 92 of the Jammu and Kashmir Constitution. My lords, as I mentioned, the High Court is constituted under this constitution, PDF page 61. Page 61, my lord. Your lordships will see 93, 94, and 95. They refer to, my lord, consultation with Honorable the Chief Justice of India. And then Please see, my lord, the powers of the High Court at PDF 65. And now your lordships will find that that 54 order was treated as a part of law applicable to them. Please see this at 65, Article 103. When your lordships read the 54 order, I showed 32.2a. 32.2a, my lord, is only in the 54 order. And here your lordships will notice the High Court will have power to issue directions writs other than those mentioned in Clause 2A of Article 32 of the Constitution of India. My lord, therefore, the linkage between the 54 order and the Constitution of India as applicable has been cemented by the Jammu and Kashmir Constitution as well. And which is why the last provision, my lord, which I have to show you, is the amendment to the Constitution 147. It has already been read. But, my lord, it is significant that the architecture of the second proviso at PDF page 85 makes 3 non-derogable, 5 non-derogable, and application of Indian Constitution provisions non-derogable. Please see that. Provided further that no bill or amendment seeking to make any change in this section or the provisions of sections 3 and 5. 5 also, my lord, is about their autonomy of lawmaking. 3 is, of course, integration with India, or the provisions of the Constitution of India as applicable in relation to the state. So, my lord, the provisions of the Constitution of India were not applied only through a 370 order. They were embraced into the Jammu and Kashmir Constitution. So, my lords, I conclude this portion by submitting that when we read Article 370, we should not be waylaid by that marginal expression temporary in the marginal note. But the entire article has worked out. Everything has worked out. It would be incorrect, my lord, to say 373 is OTOs. No. In terms of 370, they said we want to continue 370 and 1. We want only these exceptions to the Constitution, which means, my lord, they have expressly affirmed by a resolution that they don't want it to be abrogated. It is an express act of resolution. And that express act of resolution is accepted, my lord, by the government. And the order is passed. So, my lords, I submit that the vexed question, as if the Constituent Assembly was silent about the fate of 370, it is not correct. On the contrary, they wanted its continuance. They wanted it to be they wanted this to be the language of communication, my lord, between the two constitutions. So, my lord, if the Constituent Assembly of Jammu and Kashmir, which is the body of the people, if they have taken these proactive steps, we have accepted these steps, the question which arises, my lord, is, can we now abrogate this arrangement by that unilaterally? Unilaterally. Can we, my lord, can we ever abrogate this arrangement? My lord, there is nothing called hierarchies in constituent assemblies. In the definition, my lord, your lordships will find theorists have written any number of books on constituent assemblies. The nature of the constituent power, my lord, which is exercised by an assembly, is as pristine and pure as any assembly. This is, my lord, this is the equality which we have practiced, my lord. This is the level of statesmanship which India practiced and waited. Nothing was done in a hurry. And, my lord, nothing was imposed. Whatever the Constituent Assembly wanted, we accorded. We accorded it. My lord, this is the most important aspect. If this factual foundation, and this is beyond doubt, if this is so, my lord, the question is, can the legislature of a state under the Jammu and Kashmir constitution be rendered redundant? Can it be rendered, my lord, redundant? And then the question, my lord, is, what is the effect of those two COs, 272, 273? We'll go straight to them. You have only got to apply, my lord, the degree test, effect test. What does it do? 272, 273. Let us look at both these orders. And let us see, my lord, whether the power has been exercised in alignment with the purpose of the article. My lord, the theory of ultra vires in constitutional law can be either in violation of Part 3 or unsupported by lawmaking power, but there is a third species of ultra vires, if it is not aligned to the purpose for which it has been entrusted. Then in that case, my lord, it is an action which is ultra vires. These two constitutional orders, if your lordships will kindly see with me, are in Documents Volume 3. And your lordship will find that PDF 101 is the first. Now, my lord, the power which is now exercised, as your lordships can see, is the power under 370. The issue before us, my lord, is, can the architecture of Article 370 obviate the requirement of the views of the other? I'm putting other, I'll develop what is meant by other. The views of the other. This is either the state legislature or the state government. But my lord, this is an article which contemplates that there is a state and a state legislature and a state government within the scheme of the Jammu and Kashmir Constitution. And it has been used under clause 1. In my submission, the purpose of power under clause 1, my lord, is based upon a principle of mutuality. Because, my lord, the article begins with the president it doesn't mean that it is some untrammeled path. No. But there is an interesting thing in Article 371, notwithstanding anything contained in the Constitution. That notwithstanding, my lord, was necessary because there could be exceptions and modifications to provisions of the Constitution, especially for Jammu and Kashmir. And notwithstanding anything contained in this Constitution also tells us the supreme nature of this provision under 370. So, my lord, if we look at the components of basic structure, we have to look at the components of the basic structure as is reflected from the J&K Constitution, which applies the Constitution of India as applicable. Can that be abrogated? By reference to, my lord, the power under 371. 371, my lord, was a means of communication, was to respect each other. But that order does not, my lord, contain a power, if I may say so with great respect, to abrogate a legal compact. There is a legal compact, my lord. And this legal compact is of two kinds. One, of course, my lord, is the traditional social contract theory. But this compact is founded on federalism. That's why, my lord, leading authors on federalism, they often say that this is a different kind of social contract, federalism. So 370 established the contours of this relationship in the federal sense. My lord, this federal principle must be read as inbuilt in the application of Article 370. And that, my lord, cannot be abrogated. Now, please read the order with me. In exercise of powers conferred by Clause 1 of Article 370, the President, and let us, my lord, concentrate on the next few words, with the concurrence of the Government of State of Jammu and Kashmir. What is that government, my lord, contemplated by Article 370 is the question. It was a government which was elected and accountable to the Legislative Assembly under the J&K Constitution. So, my lords, if it is so interpreted, this concurrence, which one must assume is the concurrence of the governor, is not the constitutionally mandated agreement in 370. Now, my lord, look at 1(2) of this order. It shall come into force at once and shall thereupon supersede the Constitution application to Jammu and Kashmir Order 1954 as amended from time to time.
We'll return after lunch.
Certainly.
Mr. Subramanian.
Exactly. I'm grateful. Where is it? CO2 cement.
Apologies for the delay, Mr. Subramaniam.
Not at all, my lord, not at all. Lords, just before the midday recess, my lord, I was inviting your lordship's attention to CO 272 itself.
So you had made the point that para 1.2 says that CO 1954 is super.
Yes, yes.
Now,
Now, that's right. Now, my lord, the implications of this are quite serious. The implications of the abrogation of the 1954 order is completely serious and it is irreversible. The reason being, if your lordships may kindly take for a moment Documents Volume 7, PDF page, my lord, 978. PDF 978 in volume, Documents Volume 7.
Yes.
Yes. Your lordships have seen at the bottom about the resolution.
Yes,
About the adoption of the committee and forwarded to the government. And this, my lord, if your lordship sees over the page, sir, it is essential that the report of the drafting committee, which the House has passed just now, should be incorporated in the Indian Constitution. In this connection, the President of India may possibly issue a decree under Article 370. This recommendation shall become a part of the Indian Constitution according to the provisions of his decree. And then your lordships notice at the bottom of that page, 979, this is where, my lord, it is adopted, authorizes the government of the state to forward a copy of the annexure to the government of India for appropriate action. And at page 990, my lord, it's important, please see this, 990. Your lordships will find PDF page 990, Mr. Dogra. Sir, this House had last taken certain important decision in respect of the application of certain articles and entries of the Constitution of India to our state. The recommendations of the House in this behalf had been sent to the President of India, who in exercise of the powers conferred by Clause 1 of Article 370 was pleased to issue Constitution application to Jammu and Kashmir Order 54. I lay the copy of this order on the table of the House. And my lord, when we look at the 54 order, like Article 35 capital A, which has a special provision in relation to the rights of residents, the same, my lord, is actually mirrored in the state constitution. Please first see, my lord, the provision relating to Article 35A, which is at Documents Volume 3, page 15, my lord. Your lordships will notice at the bottom, 35 capital A. After Article 35, the following new article shall be added, namely, notwithstanding anything in this constitution, no existing law in force in the state of J&K and no law hereafter enacted by the legislature of the state defining classes of persons who are or shall be permanent residents of the state of Jammu and Kashmir, or conferring on such permanent residents any special rights and privileges, or imposing upon other persons any restrictions as regards employment under the state government, the acquisition of immovable property in the state, settlement in the state, or right to scholarships and such other forms of aid as the state government may provide, shall be void on the ground that it is inconsistent with or takes away or abridges any rights conferred on the other citizens of India by any provisions of this part. My Lord, exactly section 6 to 10, your Lordships may just make a note, which is in Documents Volume 2, is section 6, my Lord, of the Jammu and Kashmir Constitution, defines permanent residence. Your Lordships will find that Documents Volume 2, PDF page 18. And there, my Lord, your Lordships will find, after their definition and references, and section 9 says they will have special provisions relating to permanent residence. Section 10, mark this, my Lord, section 10 at PDF page 20 refers to the Constitution of India. The permanent residents of the state shall have all the rights guaranteed to them under the Constitution of India. So, my Lord, this is why the wholesale abrogation of the 1954 order, with respect, my Lord, which is the indication of asymmetric federalism constitutionally recognized under 370, my Lord, cannot be abrogated. Now, my Lord, there are two more defects in that order. If your Lordships will kindly come back to CO 272. Your Lordships will notice then it says, all the provisions of the Constitution, as amended from time to time, shall apply in relation to the state of Jammu and Kashmir. Now, my Lord, this militates against the principle of exceptions and modifications which could be bilaterally urged and be granted. This does away with that bilateralism. This completely emasculates the bilateralism which is inbuilt in Subarticle 1. And what it does, therefore, my Lord, is it applies the provisions of the Constitution lock, stock, and barrel, without the exceptions and modifications agreed, to the state. And the exceptions and modifications subject to which they shall so apply shall be as follows. So a new exception or modification is now carved out for the application of the entire Constitution. And that exception or modification, my Lord, is no more than what is seemingly a change in a provision of interpretation. My Lord, a provision of interpretation or to aid interpretation is an aid to construction. It is no more than, my Lord, an aid to seek and designate the correct references of expressions in a constitution. But if your Lordship sees the new clause, that is D, in this, please see the words of D. D, my Lord, says, in proviso to clause 3 of Article 370 of this Constitution, the expression Constituent Assembly of the state referred to in clause 2 shall read Legislative Assembly of the state. Is this, my Lord, interpretation? Is the question. Is this an interpretation? Is this exception, my Lord, permissible in a clause of interpretation? My Lord, in other words, if a constituent assembly and the legislative assembly of a state are, by their very nature, different bodies. They're different persona designator. Then, my lord, it cannot be an interpretation that the expression constituent assembly of the state referred to in clause 2 shall read legislative assembly of the state. This, my lord, is a direct amendment to Article 370 within brackets 3. And that amendment, my lord, cannot be achieved by an interpretation provision. This is, my lord, insofar as 272 is concerned. Let's look at, my lord, the next order, which is 273.
Page number?
This is, my lord, PDF would be 103. This is a declaration under Article 373 of the Constitution.
Mr. Subramaniam,
Sorry.
you were saying that what is done by clause D of para 2 of CO 272 is to directly amend Article 370 bracket 3, the proviso, and that this could not be done by resorting to the form of an amendment of the interpretative provision, which is Article 367.
Yes, my lord.
What if they had done that by issuing an adaptation order?
My lord, now, an adaptation order which takes place under 372, I'll just show that, my lord, because that's very interesting. An adaptation order can be passed whenever a law prior to the commencement of the Constitution, which continues as on the date of the commencement of the Constitution, needs to be brought in conformity with the Constitution. The President, my lord, can pass an adaptation order. But
there's also a power to exercise under the second proviso to clause 1.
Yes, my lord, I'm coming to that, my lord. I'm just coming to it. If your lordship...
What if they exercise the power? I mean, because we have to test whether the power is sustainable with reference to any of the other...
Yes, certainly. I'll just do that, my lord. After
the power under the second proviso to clause 1.
Let us look at that, my lord. If your lordships straight away can see that at this juncture. Please see, my lord, with me.
272 says it is issued under clause 1 of 270. Oh, sorry, 370.
Yes. The second one, my lord, CO 273 is a clear order under sub-article 3.
Right. CO 272
yes,
is specifically issued under clause 1 of Article 370.
That's right, my lord.
Now, the only provision of clause 371 which would apply is clause D.
Yes, my lord, that's right. And let us see D, my lord.
Because if they are abrogating,
yes,
for instance, CO 1954,
yes,
or they are, for instance, making an adaptation to the Constitution, both are referable to the power under clause D of under subclause D of clause 1 of Article 370.
Yes.
In which case, the only requirement under the proviso, I shouldn't say only requirement, but the requirement under the second proviso is the first proviso is that you have to consult with the government of the state if it relates to a matter covered by the instrument of accession, and the concurrence of the state government if it's a matter otherwise than what is covered by the instrument of accession, which will then lead us to who was the state government when they issued the order.
And Mullah, the question will be...
powers of the state government at that stage. And for this argument, we'll test it on the basis that the powers of the state were validly vested in the President of India.
Well, on a demurrer, we will proceed that he had powers.
Yes.
We will proceed on that footing. But the question is, can he exercise the powers under this proviso is the question. In other words, what I'm submitting for your lordship's kind consideration is as follows. The expression state government for the purpose of 370, by the very nature of that article, my lord, contemplates and validly elected, democratically constituted state government accountable to an assembly. sans that, I submit with respect, there is a polarity in 370's architecture. That is president on the one hand and the state government on the other. That polarity, my lord, under 370 cannot be merged, and the president cannot advise himself.
Are you for a moment suggesting that when a proclamation under Article 356 is in operation, there is a fetter on the exercise of the power under the second proviso to Clause D of Article 370?
My lord, that is why, with respect, I'm submitting, yes. I'm actually submitting that the fetter, my lord, is for the purpose of exercising 370. My lord, if your lordships don't mind.
At the highest is not, at the highest and at the best is not an express fetter. It's an implied limitation which you are.
It is an implied limitation. It is an implied limitation. But my lord, even though it is implied, it is strongly expressed in the architecture of the whole of 370. If the whole of 370, if your lordships accept my submission, respectful submission, is a manifestation of the constitutional principle of federalism in a manifest way, then in that case, my lord, it is necessary that both parts of the federal principle must be available for enabling an exercise of the power under 370. And there's a reason, my lord. There's an additional reason. This Article 370 is not like, my lord, what we call as provisions of conditional legislation. Article 370 is application of provisions of Constitution. That, my lord, by itself is a constitutive act. My lord, this provision under Article 370, applying the provisions of a constitution, is also a constitutive act. And if it is going to be enjoined or actually sanctioned or concurred with by the state government or by the legislature, as the case may be, it is necessary, my lord, that that polarity, that dual actors being on the scene is a sine qua non under 370.
And this second aspect, Mr. Subramaniam, which I thought I'll just place at this stage, I didn't want to place it right at the stroke of lunch, which was, while our constitution does speak about the Constituent Assembly of the state of Jammu and Kashmir, which was then in contemplation at the date of our constitution on 26th of January 1950. Significantly, after 26th of January 1957, our constitution does not speak of the constitution of Jammu and Kashmir at all.
My lord, I'll say, my lord, with great respect. The reason being that the constitution of Jammu and Kashmir, my lord, was a product which was envisaged because there was a constituent assembly. But the way it has happened is the Constitution of India, my lord, the applicable provisions were brought into the J&K Constitution, and the J&K Constitution, my lord, had its own chapters, which I have pointed out for your lordship's consideration, therefore, establishing its framework.
Our constitution speaks of only one institution, namely the Constitution of India, and the Constitution of India as it applies to the state of Jammu and Kashmir, subject to modifications and exceptions.
That's right, my lord.
Therefore, the only document, the only compact, or the only basic document that is within the contemplation of our constitution is this constitution itself.
I agree. But, my lord, now the question is, was J&K Constituent Assembly not tasked with a framing of a constitution? That is clear from sub-article 2 of 370. Under 372 and 3, my lord, if your lordship sees both these articles.
Post 1957.
Yes.
Post 1957, neither the government or the legislative assembly of Jammu and Kashmir, nor for that matter, the political establishment in the rest of the country represented by parliament, nobody ever thought of amending the Indian constitution to bring the Jammu and Kashmir constitution expressly within the fold of the Indian constitution.
My lord, it may not be necessary. I'll tell your lordships why, if I can, my lord, if I may humbly urge for your lordship's consideration. The constitution for Jammu and Kashmir is intended to be applicable to the state of Jammu and Kashmir. But it is a constitution because it is framed by a constituent assembly.
But
Well,
equally,
there could be.
the Constitution of Jammu and Kashmir imposes limitations on the power, on the executive power of the union and on the legislative power of an organ of the union, namely Parliament.
Well, the constitution of J&K doesn't impose any fetter.
The Constitution of J&K refers to the fact that, the residuary power would be vested with the...
Yes. Well, just forgive me. I'm obliged.
That is a clear fetter. I'm just giving you one example of the fetters. But therefore, there are fetters in the J&K Constitution on the operation of the Union Constitution.
Well, this is actually the asymmetry.
It was not necessary after 1957 for the Constitution of the Union, which was now the only constitution for the entirety of the country, including Jammu and Kashmir, which had acceded to India. Was it not necessary for the Indian Constitution to be amended to recognize some other constitution as an intrinsic part of this constitution?
Well, what they did was, in the order, 54 order, I'm answering, my Lord, the Chief Justice's question as an example. I'm answering the question, my Lord. If your Lordship sees the 54 order, the subject of stateless was omitted in its application. So what we have done is, with the help of the 54 order, we have imposed fetters on the Constitution. Well, that's the point for your Lordships to consider. The 54 order, by saying that under Article 246, only Article 1 will be read, 2, 3 and 4 were initially omitted in the 54 order. Subsequently, 3 and 4 were omitted. Only 1 and 2 were retained. And in the list, namely in the 7th schedule, the state list was completely omitted. It has been omitted, in the order itself. So what I'm submitting is, when your Lordship said that there is a certain degree of denudation of power which otherwise is available under the Constitution, like, say for instance, entry 97, entry 97 of list 1. But entry 97 of list 1 was in the 54 order deleted. But in their constitution, they have said whatever is the domain of Parliament, whether it is in the concurrent list or in the union list, it is entirely for Parliament to frame laws. The rest of it will be the residuary powers of the state legislature. So, my Lord, this is what I meant, that the two talk to each other. The orders, that is, my Lord, 370 orders and the Jammu and Kashmir Constitution, they both speak to each other. As your Lordships rightly said, there are some carve-outs for Jammu and Kashmir. But those carve-outs, my Lord, are volitionally done. Those carve-outs in the order of 1954, by giving them this sense that you have freedom to legislate in your spheres, was a conscious carve-out. That is the point I'm making.
But that's the problem, Mr. Subramaniam, because as you rightly said that these were volitional carve-outs. So, just as the union has therefore issued those COs, right from 1950, 1952, 1954, unless there is some higher constitutional precept which prevents them from modifying that carve-out, what is there to restrain the union from modifying the terms of that carve-out?
Unless
we were to make the Jammu and Kashmir Constitution a part of our Constitution to impose fetters on the power of Parliament or the executive.
May I answer? May I endeavor to answer?
It arises about concurrence. Concurrence and consultation, and then you have to decide whose concurrence was required in a at a point of time when 356 is in operation. If you accept your argument, during 356, the operation of 356, you cannot exercise under the second proviso to Article 371D at all.
Yes, that is one.
Then you're home. You're home completely.
But Manoj, I want to
accept that during the time that the power of the union under the second proviso to Article 370D is not denuded when 356 is in operation. In that event, The union was clearly within its power. For instance, suppose 356 is in operation. All the executive powers of the state are assumed by the union. Who issues an ordinance in the state?
Lord,
An ordinance has to be issued in a state.
yes.
Any state, state A of the Union of India. Powers under 356 are assumed by the President of India. Urgent circumstances arise, an ordinance has to be issued. Can the President not issue an ordinance for the purpose of that state?
My Lord, the difference is between, my Lord, a power to make laws. I'm submitting for your Lordship's consideration. A power to make laws. My Lord, my submission is my Lord, my submission is
Subramanian.
Yes. Lord, I wanted to answer your Lordship's observations in a serial order. The first is your Lordship's asked about the Jammu and Kashmir constitution being absent. It is not, my Lord, it is absent. It is actually, there is a recognition of the position of the constitution because many parts of our constitution under the 54 order were not applicable to the state of Jammu and Kashmir. That's the first. The second is, my Lord, the Jammu and Kashmir itself has fundamental features, is acknowledged in a passage of Chief Justice Sikri in Keshavananda Bharati's case. I'll point it out. Thirdly, as far as, my Lord, the power under Article 356 is concerned, it is conditioned, my Lord, for a certain purpose. Your Lordships have already heard submissions on it. Article 370, my Lord, does not, it is completely alien to the purpose of 356. Article 370, my Lord, is a case where there has to be bilateralism in the very nature of things. If your Lordships were to read the transposition of power in the governor and in the president, then, my Lord, the net effect is that even though Article 370 begins with a non-obstant clause, my Lord, it will be rendered nugatory. My Lord, the reason why special powers are there are only when they are conditioned by emergent needs. The scope of 356, my Lord, is emergency. And, my Lord, it is well settled. Even whatever is done during a president's proclamation in 356 cannot be irreversible. It cannot be final. My Lord, that is why it is an interim arrangement for the continuance of the Constitution under 356. Under 356, my Lord, it is not intended to be a reservoir for power for actually exercising powers under the Constitution which have nothing to do with emergency. They have nothing to do at all. Then, my Lord, I say that 370 is outside the ambit of 356 because it is not germane to the purposes of 356. And 370 contemplates and in my respectful submission, my Lord, 370 contemplates limitations on that power. These are, my Lord, express limitations. And these limitations, my Lord, cannot be obviated by taking recourse to 356. That is the point I'm making.
Yes.
These are, my Lord, express limitations. So, my Lord, I submit with respect 370 also, my Lord, is a power which is coupled with a duty. And the obligation, my Lord, under 370 is to act consistent with the very purposes of 370. And the very purpose of 370, my Lord, was to enable another assembly to take a decision, and both of them, my Lord, work together. That is, my Lord, the scheme as far as 370 is concerned.
Mr. Subramaniam, now what is the next limb of your submission?
Yes. Now, my Lord, the next limb of the submission which I wanted to urge is, my Lord, your Lordships have looked at those 4 judgments under 370.
Yes.
My Lord, I need to bring something to your Lordship's notice in those judgments. Only what is relevant for my purpose. My Lord, all those judgments, in my view, postulate the continued existence of 371. And the judgments clearly establish that notwithstanding the cessation of the Constituent Assembly, 370 would operate. And my Lord, there's a reason why it must operate. If the Jammu and Kashmir Constitution, my Lord, has to operate, 370, my Lord, has to be in existence. The application of the provisions of the Indian Constitution can happen only through 370. And because it has happened through 370, my lord, 370 cannot be used to self-destruct. It cannot be used to modify or amend itself. This, my lord, is established in the judgments itself of your lordships, which I'll presently point out. The second is, in Sampat Prakash, there is, my lord, an express statement which is supported by legislative record that the Constituent Assembly did not abrogate but insisted on the continuance of Article 370. If that is so, my lord, I submit that Sampat Prakash takes the position that 370 is there to stay. And my lord, there is another important aspect. Why is it that the J&K Constitution was not taken note of by an express constitutional provision? The answer to that also is as follows, my lord. The power to amend the J&K Constitution, being a constitution created by a constituent assembly, can only lie with the body which has been created by that constitution. That, my lord, is settled law. That if a constituent body or a constituent power prescribes a constitution and elects a body under that constitution, the power to amend that constitution will lie with that body. So the body, my lord, which is competent, I'm so sorry, my lord.
But Subramaniam, on that there may be a slight issue for the simple reason. One, when we read the earlier part of 1954 order, it was quite clear that the Indian Constitution has been adopted with the omissions and modifications. We may call it a J&K Constitution. It may have been referred to as J&K Constitution, but what is adopted is the Indian Constitution with exceptions and modifications. One. Number two, Article 370 by very nature is very flexible. It's flexible. And normally constitutions are flexible in time and space because they are made once, but they last for a long time. Yes, we have the basic structure doctrine, and that argument of yours that basic structure is there. But if you look at 370 itself, it's a flexible article. It says that modifications can be done to ensure that the Constitution of India, as applicable to the state of J&K, should assimilate whatever is applicable in other parts of the country.
My lord, with respect, I think I have to give, my lord, an absolutely candid answer. My reading, my lord, of the Article 370, in the light of the structure of Article 370, 1, 2, and 3, my lord, orders may be issued under 371, but they have to be based on bilateralism. And that bilateralism is necessarily to involve what is agreed upon by the state or in turn the legislature. Sans the state, sans the legislature, I submit, my lord, it will not be consistent with constitutional principles to interpret 370 as if it can be done unilaterally. Well, the choice is as follows. Can the power be exercised under Article 370 unilaterally? My answer is no. The second, your lordship said it is a constitutional power. I completely agree. Third, but my lord, asymmetric federalism by its very definition means special provisions for special places or states. Like, my lord, you have provisions in the Constitution.
That is basically bilateralism and federalism, which is inbuilt in 370. If it is violated, then that flexibility is taken away.
Yes, then becomes ultra-virus, my lord. Then it becomes ultra-virus 370. I'm very obliged for putting that question to me. My lord, I can't. So federalism and supremacy of the Constitution are, my lord, conjoint principles. both supremacy and federalism. And if both of them are injected or infused, but not necessarily in 370, then we have to see whether the exercise of the power under 370 can be destructive of those principles. That is the point, my lord, in this case. And there is a crucial point, my lord, which we must consider. The Jammu and Kashmir constitution, my lord, can be overturned, repealed by that legislature. But it cannot be abrogated by us. My lord, that constitution is also a document. It is also a document which is a legal document. It is both a normative document and a prescriptive document that has constituted, my lord, the legislature. The organs of the state have been constituted under that constitution. It is, my lord, entitled to be noticed. That constitution, my lord, cannot be wished away or abrogated unless the power to override that constitution can be located somewhere. My lord, this is the point here, that without there being an express provision in the constitution to override the Jammu and Kashmir constitution, my lord, what your lordships will see in CO 273 cannot happen. CO 273, if your lordship sees now with me, my lord, it abrogates a constitution. And that, my lord, cannot be done at all. Please just look at, my lord, for a moment, the document.
Mr. Subramaniam.
Yes, I'm so sorry, my lord.
No, Mr. Sibbal's own argument was that as the orders were issued from time to time, very little remained inside 370. Actually, that was his argument, that very little remained inside 370. So, do we have any examples where, when these COs were issued, there were any negative comment on it from the assemblies or any of the situations?
My lord, that is what I'm submitting. All the COs, which your lordships will notice, some were issued, my lord, before the dissolution of the Constituent Assembly of Jammu and Kashmir. It's to dissolve, my lord, on the 20...
No, I'm talking about the post-1957.
Yes. Now, post-1957, my lord, there were orders which were passed. Those orders were with the concurrence of the government. They were with the concurrence under D, the other provisions which your lordships mentioned. For instance, Article 356, I'll give your lordships as an example. Article 356, my lord, was omitted in the 1954 order. It was applied for the first time in 1965 by a constitutional order. And your lordships have seen that in Article 356, the words are, in order, in accordance with the provisions of this constitution. So, my lord, it was in the constitutional order, Article 356 was applied, saying the provisions of the constitution in Article 356 will mean provisions of the Jammu and Kashmir constitution. I can show that order, my lord, just as an example. That 356 itself came much later. My lord, it is not correct to say that by virtue of 370 everything has happened. No, these exceptions and carve-outs have continued. These exceptions and carve-outs have continued from the 54 order, which is why what is today abrogated is the parent order 54 as amended from time to time. Well, that is why it is necessary to bear in mind that these adaptations were based upon bilateralism. These modifications were based on bilateralism. But one important feature which I may bring to your lordship's attention is, in Article 372, my lord, there is a proviso that the competent legislature can pass a law even after a president passes an adaptation order. That, my lord, is not existent here because the legislature under 147 cannot do anything to the provisions of the constitution as applied in Jammu and Kashmir. May I, my lord?
Yes, Mr. Raman.
Sorry. My lord, I may now straight away point out to the 2 or 3 things in the decisions.
Mr. Subramanian, just one small clarification I had.
Yes, certainly.
What
Please.
happened to the instrument as a matter of law? What happened to the instrument of accession after the Constitution of J&K came into being?
My lord, the accession, that instrument of accession, my lord, really speaking, after the Constituent Assembly decided to accede, it was ultimately, my lord, that decision which operated. The instrument of accession, my lord, was done initially in 48, as your lordships recollect. But in that instrument of accession, there was a clear reservation that I'm not making any commitment to abide by the Constitution. My lord, there were some conditions, reservations placed in it. But normally, my lord, if suppose accession had to take place through the Maharaja, then there would have been a supplementary instrument of accession and a merger agreement, as was done with many others.
So
Whereas
once the
here,
Constitution of Jammu and Kashmir recognizes that Jammu and Kashmir accedes to the dominant status of India,
yes,
that it becomes a part of
Yes.
India,
yes.
would it be correct to say then really that instrument of accession ceases to exist as an independent document in that sense?
No, my lord, it did enable accession. Let me, for the purposes of sovereignty, my lord,
What would be the status of the instrument of accession once the Constituent Assembly of J&K designed and promulgated the J&K Constitution?
my lord, if I may say so with respect, the instrument of accession is a historical fact. It's
Would
a
it be
historical
subsumed in
fact.
that?
I'm sorry, my lord. It's a historical fact.
Would it be subsumed in the state constitution?
Yes, my lord. Yes, because the state constitution itself recognizes the accession in 48. May I show that, my lord? May I show that? The constitution itself recognizes.
Is subsumed now in Article 370, and only to the extent Article 370 refers to it, it will be applicable.
It has no use after 370 because
Yes.
it incorporates those matters in 370 automatically.
Well, the instrument of accession was for a very limited purpose at that time. But, my lord, matters later on, as your lordships have seen, there was the Constituent Assembly and accession was complete. And the Constitution of J&K itself, my lord, has declared that integration to be complete. That was the decision of the
Mr.
people.
Subramanian, the reason I asked you was this. Now I'll tell you why I asked you this question. Could it conceivably be that the fetter on the power of Parliament under Clause B of Article 371 was also a limited transitional provision which would operate so long as the instrument of accession held the field as an independent document?
No, my lord, there is no evidence to that.
Once the instrument of accession gets subsumed in the post-constitution document evincing a transfer of power, then to the extent that the instrument of accession itself has been subsumed, then the fetter on the power of Parliament cannot be relatable to the instrument of accession, but has to be found somewhere else.
My lord, I'm grateful. The fetter, my lord, on Parliament is by virtue of 370 and, my lord, had no direct relation with the instrument of accession. If I may just point out, my lord. 370 was there as your lordships have seen in 1950. At that time, there was only an instrument of accession. After the Constitution came into force, it is only in 1951 that the Constituent Assembly was constituted. And then, my lord, the Constitution was finally enacted in 1957. But between 51 and 57, My lord, the instrument of accession, my lord, is already on the record. It is in document 1.
As we have seen,
Yes, your lordships have seen.
Yes.
And my lord, that is very clear that it is a period of transition. But that period of transition and the fetters being imposed on Parliament, my lord, that was not the cause of 370. If I may say so, I've understood what your lordships are putting to me, that before a new sovereign body of legislature takes complete effect, is it not correct that the old is wiped out, or there may be some a purely transitory provision? But this is not, my lord, a transitory provision. That is why, my lord, E370, in its true essence, is not treated as a transitory provision, but is actually a substantive provision meant to operate over a period of time. Then, my lord, it is clear that concessions which have been sought and granted by, my lord, again, by the Union government, by accepting the recommendations of the Constituent Assembly, I submit, my lord, with respect, then they get embedded into law by operation of 370, as well as, my lord, by virtue of Section 21A of the Government of Jammu and Kashmir Constitution.
Now, Mr. Subramanian,
Yes.
you've given us the
Yes.
Constitution bench decisions.
Yes,
According to you, postulate the continuance of Article.
that's right, my lord. That is that
Made your
Sampat.
point on Sampat Prakash as
Yes,
well
that
as
is para 8. Now, my lord, this judgment in Damnu, which has been cited, I just want to just take 2 minutes, and I'll take your lordships to Chief Justice Sikri's judgment, who makes a comment on this in Keshavananda Bharati. But, my lord, in Damnu's case, the facts were as follows, my lord. The Jammu and Kashmir Legislative Assembly amended the Constitution of Jammu and Kashmir in 1965 by the Sixth Amendment Act. As a consequence of the Sixth Amendment, they replaced, my lord, that expression Sadare Riyasat with governor. The amendment first took place, my lord, in the J&K Constitution. Therefore, my lord, in order to see that that was reflected vis-a-vis our Constitution and Article 370, there was, my lord, in the interpretation section, your lordships have seen, that was buried. That, my lord, was challenged. The amendment was challenged. The Constitution amendment, as well as, my lord, the order in amending Article 367, one of the explanations was challenged in Damu's case. In Damu's case, Chief Justice Sikri said that what has been done by the order explaining that the Sadare Riyasat is now governor is in conformity with the Constitution 6th Amendment of J&K, and therefore there is no impairment of their basic structure. But, my lord, the learned judge has actually, if I may say so, relied upon an excerpt in Keshavananda Bharati. In Keshavananda Bharati, where, my lord, the word amend was so widely worded, if your lordship sees one paragraph in Keshavananda Bharati, that is, my lord, that is Case Law Volume 15, and the relevant portion, my lord, which I wanted to show, is para 306, PDF page 174. And Chief Justice Sikri, my lord, refers to his own judgment. And he refers to it, my lord, to support the position that the fundamentals of J&K Constitution were not impaired. Please see para 306, PDF 174. Reference may be made to Muhammad Maqbul Damnu versus State of Jammu and Kashmir, where this court repelled the argument of the learned counsel that the amendments made to say...
Mr. Subramanian, just 1 second. You're on Case Law Volume 15.
1.5, my lord.
1.5.
Yes.
And PDF page?
PDF page 174, my lord.
174.
Yes, 306.
Yes, Mr. Subramaniam.
Yes, para 306, my lord. Reference may be made to Muhammad Damnu versus State of Jammu and Kashmir, where this court repelled the argument of the Learned Counsel that the amendments made to sections 26 and 27 of the Constitution of Jammu and Kashmir were bad because they destroyed the structure of the Constitution. The arguments of the Learned Counsel was that fundamentals of the Jammu and Kashmir state constitution has been destroyed. This argument was refuted in the following words. But the passage cited by him can hardly be availed of by him for the reason that the amendment impugned by him, in the light of what we have already stated about the nature of the explanation to Article 370 of our Constitution, does not bring about any alteration either in the framework or the fundamentals of the Jammu and Kashmir Constitution. The state government still continues to be the head, governor still continues to be the head of the government, aided by a council of ministers, and the only change affected is in his designation and the mode of his appointment. It is not as if the state government by such a change is made irresponsible to the state legislature or its fundamental character as a responsible government is altered. And then, my lord, please see the last sentence. There is no question of such a change being one in the character of that government from a democratic to a non-democratic system.
Right.
And my lord, I submit with respect, when we look at the exercise of power under 370, my lord, it must be informed with the idea that it should not offend any of the basic principles of the Constitution. And the two principles which I invoke, my lord, are federalism, and my lord, federalism as its subsect has autonomy and consent. The principle of federalism, my lord, is always autonomy and consent. And the other principle, my lord, is supremacy of the Constitution. So supremacy of the Constitution here, my lord, I wish to point out that the purposes of 356 and 370 are not coincidental. They do not coincide. And because they do not coincide, the exercise of power under 356 cannot clothe you with legal authority under 370.
Now, what else, Mr. Subramaniam, remains
I
for
think,
you?
my lord, I've kept my word. I've honored my word. I said I wouldn't take more than a certain amount of time. But, my lord, I would request your lordships to ask any questions your lordships may consider.
I think, Sanjay.
Been doing, Mr. Subramaniam.
Rajiv, Suryakanth. Thank you so much, Mr. Subramaniam.
Thank you, my
Very
lord.
brief
I'm
and very incisive. Thank you very much.
Thank you.
Thinking.
Grateful,
Thank
my
you
lord. Great.
Mr. Zaprashan.
Much has been said, my lords, by the learned counsel who have already made submissions. But speaking for myself, we belong to that state and we have lived through this 370. We have been brought up in this 370. It's a part of our mindset, this 370. And we were really shocked when the notification of 272 was issued on 5th of August 2019. It was unexpected and one could never imagine that this could so suddenly happen. Because in order to understand this 370, there are few approaches to its understanding. One would be in the first instance, if the Maharaja way back perhaps before the birth of all of us, when he entered into instrument accession only, why didn't he enter also into merger agreement at that point of time? This debate would not have been here. It could have been straightway a part of the Union of India. He did not do that. So that's a question which needs to be inquired into. Why didn't he do that? That's number one. And number two, if he only entered into instrument of accession, what is it that he parted with as a sovereign king? And what is it that he retained with himself? My understanding of the case is this, and perhaps many things will become clearer, that the Union of India by itself was one authority. This Maharaja of a state, of a very large state among the native states, was another authority. When the Indian Independence Act was passed, Government of India Act 35 was applicable, they became all independent sovereign states. All these native states, including the state of Jammu and Kashmir. When we proceed on the premises that they became independent sovereign states, then comes the question of accession to either of the dominions. All other states in India, native states, whether they were as small as 1 kilometer or they were big states, either they merged with themselves, but ultimately all of them merged with Union of India. And this merger word is extremely important, and I think that's the basis of this 370. He did not enter this merger agreement at all. He entered into standstill agreement only with government of Pakistan. The government of India did not agree to enter into the standstill agreement. This was the situation in 1900, prior to 1947. Nonetheless, because of the extraordinary situation which arose in the state of Jammu and Kashmir, having no choice in the matter, he enters into this instrument of accession on 26th of October 1947. What does he do under this? He, in simple language, he says that the Union of India will have the power to make law for defense, communication, and foreign affairs. He doesn't give any other power to them, only these three subjects. But for remaining subjects, I mean, running a country, you need so many laws. For remaining subjects, he retained all the powers with him under clause 8 of this instrument of accession. Now, in the absence of merger agreement, obviously these laws, this power to make the law, and where he had this legislative autonomy, could not have been transferred in the absence of such an agreement. This is the situation. He left. Thereafter, he asked his son to take over. His son takes over Dr. Karan Singh. He also does not enter into any kind of merger agreement or supplementary agreements. This is the situation on the one side. On the other side of the picture is that so far as the government of India is concerned, it was already in the process of making the constitution. That was not meant for the state of Jammu and Kashmir, but for the entire country. All native states have merged and ultimately become part of the Union of India. All those native states. There were three only left. That was Junagadh, that was Hyderabad, and state of Jammu and Kashmir. So far as Junagadh is concerned, there the king belonged to a certain sect. He wanted to accede to Pakistan, but the people did not want it. So therefore, they ultimately held a referendum in Junagadh on 20th of February 1948, and the people overwhelmingly voted to be a part of India. So far as Hyderabad is concerned, the situation is altogether different. Ultimately, Hyderabad also merged with India. But state of Jammu and Kashmir, out of these three, did not enter into any kind of an agreement. It remained a separate state, but with only power with the union on these three subjects which I mentioned. But when this Constitution of India was being made, a significant development takes place at that point of time, which had its impact on this relationship, which was normally between a native state and the Union of India. That is, the situation arose in the state of Jammu and Kashmir such that the matter had to go outside the country to United Nations. When it went to the United Nations, as many as 5 or 6 resolutions were passed there. They also said that this instrument of accession should be put to the people's ratification. This is on, not only they said it there, on 27th of October letter, which has already been read to lordships, it also said that as and when the situation in Jammu and Kashmir becomes normal, this particular instrument accession will be put to the ratification of the people. It does not take place. The UN security resolutions do not take place. But yet, the Constitution of India was being made, and there was only instrument of accession. These are extremely three factors which resulted in making this Article 370. Now,
What are the three factors? What are the three factors? We can just itemize them.
No merger agreement?
Just one second.
Yes. October 1947 letter of the Governor General. And 3 UN resolutions.
Fisher, who are you appearing for? We'll just for matter of record.
Appearing?
Which petition are you appearing?
Bar Association.
Bar Association.
Yeah.
Which is that writ petition number? 1268.
I may be excused for because my files are not that organized as I see my senior friends who are not much used to this.
You possibly don't need.
System. We still have physical files with us. I may be excused for that.
But I don't think you need the files.
We also have my AR will give a lot of the number.
1268. 1268.
21, yeah.
This is the Bar Association, is it?
So the third factor was UN resolution. These were the three factors. Now this is the situation preceding making of this Article 370. Now when it goes to the Constituent Assembly, at that point of time, the representatives of Jammu and Kashmir were not there in the Constituent Assembly. They become members in June 1949 after amendment is carried out in the procedures of becoming a member of the Constituent Assembly. So we have the representatives from Jammu and Kashmir in June 1949. By that time, almost entire Constitution of India had been adopted. Because finally the Constitution is adopted on 26 November 1949. So hardly few months are left when the representatives of Jammu and Kashmir become members of the Constituent Assembly. Then in October 1949, this article, which was originally 306A, is debated. In that debate, which references can be made, I'm just giving the narrative to the whole case, but I'm standing here for. There, the mention expressly is made that, look here, the position of the Jammu and Kashmir is uncertain. Why is it uncertain? It was uncertain because, number one, of the Governor General's letter of 27 for 1947, and the government of India being entangled, that's the exact word used in the Constitutional Assembly debates, being entangled before United Nations. So one doesn't know what happens, whether this is going to stay, this is not going to stay, whether it should merge with India, it should not merge with India. This is the situation existing. And it is in this background that somebody had to think of, what do we do with this state? It had entered into instrument of accession. It was one of the federating states, if I put it that way. But this was not fully a federating state, like any other state, because of the absence of merger agreement. So some way had to be found. Madhur's observation was correct, that after this instrument of accession is executing and 370A is made, if we look at 370A, it seems to absorb, subsume within itself that power which the king had, the Maharaja had. What is the power which he had retained with himself? He had retained the entire residuary, if I say so, sovereignty with him. What was the concept of sovereignty? The power to make the law. What does it mean, sovereignty? That is the whole thing. The power to make the law. He had retained that with himself. I'll make the law, except on these three subjects. Law related to defense, law related to foreign affairs, law relating to communications. All other powers I will retain. Then the question further arose, now what happens to Jammu and Kashmir? We need a constitution. How do we run the state? We earlier had a constitution of the Maharaja, that's of 1996. But the structure of the constitution was different. There was Praja, there was the king. He had the exclusive power under section 5 and 6 of that act. He could do anything. But since the democracy had set in, so therefore that particular constitution had become inappropriate. That's why Dr. Karan Singh in his communication said, because of the change of situation, we need a new constitution. Why the need for new constitution? Because the state had retained with itself the entire powers. So here essentially also we are concerned with the right of the state of Jammu and Kashmir. It's not the right of an individual. It's not simply the right of the people of the state. It's the right of the state which is in question. That what kind of right is this state possessed under the instrument of accession? So sir, this Article 370 is based, according to my perception, it is based, number one, that it subsumes the sovereignty which was retained by Maharaja, number one. And number two, at the same time, its finality could not be determined of the state itself, not of Article 370, but of the state itself, because the dependency of the matters which are indicated.
Zafar Shah, what is the second point? The first one you said is that Article 370 subsumes the sovereignty which was retained by the Maharaja.
And number two, I said,
So when you say subsumes the sovereignty, are you therefore suggesting that sovereignty still continued to reside in the state?
370 itself, but which kind of sovereignty?
370. Sorry, yes.
Power to make laws, sovereignty or power to make law. There could be semi-sovereignty, quasi-sovereignty, there are different types of sovereignties. I'm here focusing on the power to make laws was retained. In terms of this
Would
370.
that really be a correct reading once accession takes place? And what happens is that there are certain fetters, there are certain reservations which are retained in the instrument of accession, that he unconditionally recognizes the sovereignty of India, but he retains certain exceptions. He carves out certain areas which he retains to himself. He says, I am surrendering the power to make laws only in reference to defense, foreign affairs, and communication. Broadly, the three heads.
I give it to you.
That's right.
He donates the power.
But what does accession really mean? Accession means that, Jammu and Kashmir becomes a complete and intrinsic part of India. There would be no going back on that, isn't it?
No, one view would be that whether in terms of territory it is transferred. So what do we mean by accession, the word? One would be the territory itself is transferred to India. Means that de facto, the union government is in possession of the state of Jammu and Kashmir, but de jure, the sovereignty is not transferred to the Union of India.
Or would it be the correct reading would be that for that matter, say, take any other state. Take the state of Uttar Pradesh, Maharashtra,
Yes.
Tamil Nadu.
Yes.
There are certain fetters even on the power of Parliament to enact laws. Parliament cannot enact laws at all with respect to List 2. Parliament Parliament can enact laws only on List 1 and List 3. In relation to, say, NCT of Delhi, which came in 1992, Parliament can enact laws on List 1, 2, and 3, but the state legislature of Delhi cannot enact laws under List 2 on entries 1, 2, and 18. So there are different models which the Constitution is following.
Possible, yes.
What seems to happen with the instrument of accession is that sovereignty is transferred and recognized in the dominion of India. But the power of legislation, because legislation is an incident of sovereignty, but legislation is not the entirety of sovereignty. Legislation is one aspect of sovereignty. On that aspect, namely legislation, the power is not entirely recognized as inhering in the Parliament of India, which it otherwise has in relation to the Union List and the concurrent list. But notwithstanding this, the instrument of accession says that unconditionally you are acceding to the dominion of India.
No.
Just one. Paragraph 4 of the letter says, I hereby declare that I accede to the dominion of India.
Accede.
And then he says that if an agreement on the assurance that if an agreement is made with the Governor General and ruler of the state whereby all any functions in relation to administration of any law so and so shall be
Supplementary agreement.
exercised. But 5 then goes on to say that the terms of this instrument of accession shall be not be varied by any amendment by of an act or Indian Independence Act unless such amendment is accepted by instrument supplementary to this instrument.
Very right.
Now, what
He doesn't-
happens is when in the
He does not.
constitution, when one is accepting that you are now merging with India, except these powers will be, or as pointed out, these legislative powers or these administrative powers will be still vested with the ruler. And it is subject to the condition that by supplementary instrument that can be further diluted, not the power taken already, the sovereignty which you have merger which has taken place, but with regard to that. Then when you become a members of the Constituent Assembly, and then you decide how it goes about with passage of time, you participate in the minutes. Then there's a Constituent Assembly also for the state of J&K. Now, will it be correct to then go back so much in point of time?
First of all, my lords, which you also read, kindly see clause 8 also, which gives to the Maharaja, he retains all the powers with himself, except in respect of these 3 subjects. He retains all the powers. Now, when he retains all these powers, should I read that to your lordships?
Yeah, I've got it.
Your lordship. When he retains all these powers with himself, what is to be done with this? You exceed whatever the meaning of that accession may be, let's take it like that. But is it not also an act of state between the Union of India and the state of Jammu and Kashmir? This instrument of accession is an act of state. The 2 states say, 2 independent states say, 2 sovereign free states say, look here, I agree to be with you. I will shake hands with you, but I will not embrace you, if I put it that way. Metaphorically, if I put it, I'll shake hands with you, but I will not embrace you. Done by the king. Why king did that? History tells us that he wanted to retain the Jammu and Kashmir as an independent country. That's the whole basis of it. Otherwise, nothing prevented him, like any other native prince, to merge with India, to totally erase itself of its statehood. What is it that if you enter only into instrument of accession, do you still retain sovereignty with you? We have the judgment of this court as I unfold my submissions. I'll show the judgment. You retain the sovereignty. You don't surrender the sovereignty merely by instrument of accession. Yeah, of course, you do that. Of course, you do that subject to 2 conditions. 1, your standstill agreement, and number 2, you have the merger agreement. And both are provided for in the white paper of states issued by the government of India. He doesn't do that. See this problem of ours, problem of the state of Jammu and Kashmir. When he doesn't do that, and as a 2 separate states, he says, I agree with you, but I'm going to run my own state myself. You take care of my defense. You take care of my foreign affairs. You take care of my communication. The government says, okay, we'll take care of these 3 things. Because situation had emerged in the state where the help was needed from India and the Indian army landed there. So he says, look here, you take these 3, but rest I run my government myself. That was the whole intention. Original intention of the Maharaja when he executed instrument of accession. Now, when subsequently few changes take place, he leaves the state, his son also does not do that. But yet the constitution is being made. What do you do with this state? I have not merged, so you don't treat me as one of the states of India. But yet, I am a part of the federation. I am a federating unit. Therefore, this special relationship. Therefore, the genesis of Article 370, this is the special relationship between the state of Jammu and Kashmir and Union of India. The extent and other things, we'll debate that as well. But this is the special relationship between the state of Jammu and Kashmir and the Union of India. What should the Constitution of India do with such kind of a state, which has not merged, which has yet asked me to make laws for it, and yet remains separate? Therefore, 370 makes mention significantly of instrument of taxation and making of the constitution. Because constitution was required. The state did not need 1939 constitution at all. Constitution was required. Therefore, the letter of 1st of May 1951 saying that we have to constitute a constituent assembly for the state of Jammu and Kashmir. When by that date, the Constitution of India had already been adopted. So consciously, on the one part, the federating state, on the other part, the Union of India agreed that the state of Jammu and Kashmir, perhaps, it looks like American Constitution. Your Lords would be well aware that there are two constitutions, one of the state, one is a federal constitution. Something on those lines, only for state of Jammu and Kashmir, not for any of the state in India. And I would go to it and say, once all states merged, they lost their personality. Even if tomorrow, I mean, going by this perspective, if tomorrow state list is not given to the other states, they can't say, sir, we agreed on this condition because they merged. They don't exist. Either under international law or under the domestic law. They don't exist. But our state was the only one which did not merge at all, so retained itself, a separate personality. Some part of the statehood was retained with it. Therefore, 370. Now, what does the 370 say? Look at so far as the power to legislate is concerned. I say, I have a choice. You do that with my concurrence. Your parliament, you have list 1, maybe list 3, you have all the powers, all plenary powers. But you will not, it will be limited to your plenary powers, whether it's under list 1 or list 3, will be limited to by my concurrence. If I agree, yes, on a subject, please make the law for me, then only you will make the law for me. Not otherwise. Similarly, with regard to the constitutional provisions, I had my own constitution. I made provisions in my own constitution, whether it is High Court, whether it is Advocate General, whether it is the state legislature, whether it is the membership of the members. I made my own constitution. Now, when I make my own constitution, and on this, at the same time, I also agree through the mechanism of Article 370 that you apply A, B, C, D constitutional provisions to me. I have to take care of it, that they don't come into conflict with my constitution. I have to take care of that.
We'll continue tomorrow morning. Come on. But you can make an objection provided there is some dimmer on our side.
Are not sure what you want to argue, you will still have the same time. And this is a very peculiar request to make, I think, honestly, at the end of the day.
And in the midst of the arguments.
Yes, I tell you.